Hey, good afternoon, everybody. Thanks for your patience. I sound a little bit stuffed up just because my kids brought something over from their school about a week ago. Many of you have probably been in that situation. I don't think I'm contagious, but I'll keep my distance. It's been a couple of weeks. Still got this lingering head cold, but glad we got a good number of people here. I think these are some pretty important lessons that we're going to go over. Tina asked me to cover the top 10 mistakes that I see come through Pike Title, and we do over 1,000 closings a year, so 99% of those are fine, but even 1% is significant enough where it takes our attention. And so I focus on the things that we see. I focus on the things that I've heard or dealt with in person, and I'll go over them and spend as much or as little time as you all want based on your own personal interest. But I'll give you kind of the overview of each of these 10 things. Since there are 10, I'm not going to take deep dives into each single one because they probably could be the subject of a separate lesson on each one of those. But hopefully by the end of this, you'll all have a little bit of knowledge that you didn't have coming into it, and it'll improve the way that you're able to interact with your clients. All right, so now the countdown. And I kind of did this from 10 to 1, thinking that kind of 1 was the one that I saw the most, 2 a little bit, but between like 10 and 6, I was not in any real particular order because I don't know which one's fine. Number 10 is listing without permission. All right. And so when I say listing without permission, what I mean is who owns the property? Who signs the listing agreement? Is the person who then goes to sign that contract when you have a qualified offer able to convey the property that you advertised? And surprising as it may sound, we see this quite a bit where people who are, a realtor will go on a listing appointment. They'll meet with one individual who presents him or herself as the owner of the property. They sign a listing agreement. They'll advertise in the MLS that this is the owner of that particular property. But come to find out, usually when a title search is done, or when an angry divorced spouse comes out of the woodworks, that's when we find out that, oh, by the way, this person isn't the only owner, or maybe they're not even the owner at all anymore. That can cause some really big issues, not only for you as a realtor, because you've now represented to the world through the MLS and probably through conversations with various parties, including listing realtor or selling realtors and clients, interested parties. So you may be on the hook for certain misrepresentations, whether they're intentional or unintentional. But even more importantly, that prospective buyer may not get that house or may not get that piece of property that they thought they were going to get. And if we find out these issues toward the end of closing, that can be a really big and devastating problem for that individual. And if there's liability that can be traced back to you as an individual realtor, the bigger the problem that the buyer faces, the more expensive the liability may be for you. And so I'll give you a couple of examples of what this might look like. Based on stories I've heard or representations that I've had. It is not uncommon for a married couple to buy a house as a tenants by entirety, meaning that they both own that house together. They're joint owners. It is also not uncommon for spouses to get a divorce. And when that happens, there is a distribution of assets. And real estate is sometimes the most difficult asset to find out how it's distributed, who gets what happens with it. And sometimes people will go through a divorce, they'll get an order from a court, the order is called a decree, and that'll even be recorded in the land records. But for whatever reason, the additional step of dividing that real estate never took place. And so what you may find is the person living in the house in their settlement agreement in their divorce was entitled to that house. They were the owners of that house, and they probably have been living in that house without anybody knowing it, or without anybody being concerned about it, and thinking that they were the sole owners of the house because that's what the judge said. But come to find out, there was never a deed recorded in the land records that transferred that house from the couple to that individual. There's an additional step that needs to take place, and sometimes for whatever reason it just doesn't. And so when we get to title, when we get to this point at Pike Title where we're looking over the land records and we're trying to see who owns what, come to find out that the last deed of record is to Jane and John Smith, husband and wife, and not to Jane Smith, who's the only one who signed your listing agreement, who's the one who thinks she owns the house, and who's also the one who has signed the purchase agreement. And so when that happens, sometimes it's kind of easy to resolve if the ex is cooperative and available and we can find them, we can get them to sign a deed. But if they're gone, if they're estranged, if they're just angry and they don't want to cooperate, then all of a sudden we have problems that can sink a closing. And all of that could have been resolved through a little bit of investigation. So one of the things that I always recommend for realtors is if you haven't used the GIS or tax records for a given city or county, it's a public resource, it's available online. Everywhere in this area has them. And what you can do is you can log in and type in an address, you can type in an owner, and it will pull up exactly what the tax records reflect. So sometimes it's not 100% accurate, so you can't completely rely on it, but it's a pretty good starting point, especially if you're in a situation where you have some concerns. Either a divorce situation or if somebody passed away and now there's a bunch of heirs, that may be an opportunity to look at the GIS. Or if it just seems a little bit suspicious for whatever reason, it's an easy thing to do a search. And what the GIS will do, or the tax records, some counties have, so the GIS is kind of a mapping program. Tax records are sometimes fed into that GIS, and counties maintain records of ownership so they can figure out when to send those tax bills to. Those records are always accurate, but it's a good starting point so you can get at. If you can, though, the best way to confirm who owns the property is to ask for a copy of the deed. Most people, well, I shouldn't say most people, some people keep copies of those in their records because they'll either get an email or they'll get a packet at the closing when they purchase that house and they'll put it in a file somewhere. And if you ask, maybe they can find it and get it for you. Sometimes if there's a real concern, you may even ask the clerk of the court where the property is located, because every real estate transaction is reported in the clerk's office. And so if it's in Lynchburg, it's going to be in the downtown Lynchburg city office. If it's in Campbell, it's going to be in Rushburg courthouse. And those clerks are typically pretty helpful. It varies, but most of the time they'll help you out if you're nice and you ask them nicely. But you can look up where the latest deed. You can look up any land record really, but you could type in the property address or the owner's name and it'll show you what the last deed of record is. And that deed, if you know enough about deeds where you can see who the grantor is, that's the current owner. If you look at the last deed, whoever's listed as the grantor should be the owner of that property. So those are some ways to kind of avoid the mistake of listing without permission of all the people who need to give you the permission, whether that's both spouses or all the heirs, or any other owners that may not be the ones that you speak to directly. And avoiding that problem at the beginning saves a lot of trouble at the end and potentially some serious liability for you as a realtor.
So I always think about, because, I am, the principal broker, like what is going to be, if you did it in front of a judge, he's going to say the GIS is public. So so when I go to my listing appointments, I actually have it printed out.
Yeah.
And I make sure the names agree and, and where's this person if they're not on there. So at least I feel like that's the minimum. If it's public record, like we're going to be on the hook if we haven't at least gotten that part right.
Yeah.
So, and then if they is an heir or a divorce or whatever, I'm like, could you show me your, that you are the executor of this estate? Because sometimes they say they're executor, like,
yeah.
And if we're not clear, we
point.
could send it to you, right? And you could be like, yes, they can sign the 4 heirs because he's the executor.
POA or.
Right.
Yeah.
Yeah, a couple things on that actually. So for executors, it's quite common for people to pass away without a will. And when that happens, there is no executor. And some people kind of confirm the term or confuse the terms executor with administrator or personal representative. An executor is somebody who's appointed in a will. Typically, they have the authority to convey property all by themselves. If there's not a will, there still may be somebody appointed by the court called a personal representative. But that person does not have authority by themselves if there are other heirs. And so even though they may think they do. And even, I've even heard situations where the clerk has misadvised them and told them they have a property. Unless a judge has issued an order, like there's been a court process and the judge has issued an order granting a particular person authority, if there's not a will, all the heirs must sign. They must sign the listing agreement and they must sign the purchase and sale agreement. So that's always something to pay attention to. But yeah, as far as like the minimum due diligence, what we're always trying to avoid is this kind of amorphous legal concept called negligence. We don't want to be considered negligent. And so what does it mean when to be negligent? It means that you didn't exercise ordinary care. What does that mean? It's another legal terminology. It's basically what others in your industry would be expected to do under similar circumstances. And so if an ordinary realtor exercising ordinary care would bring or who would check public records like the GIS before going to a listing agreement, and you didn't do that, then you're negligent. And I would say that it's probably safe to assume that if it's available and it's easy to access, that it's the standard. And so anything below that may be considered negligence. So yeah, both good points on that.
I just ran into a situation where there was full of blocks to the parcel. 2 of the blocks had been transferred in the prior sale and 2 had mistakenly been left out.
Yeah.
And so the guy really didn't own all the property. Now they, you know, it was just gifted to him after that because it was just a mistake, but you know.
Yeah, title issues like that come up all the time, especially with estates, because somebody passes away, or maybe there's a conveyance that's not recorded right. So yeah, things like that come up all the time. But the truth is, you're not going to know about every single title issue before you get through the title search. And so the goal is not to be perfect, but the goal is to exercise ordinary care. The goal is to make sure that you check the boxes. Did I look at the resources that were accessible to me before getting the contract signed, before getting the listing agreement signed? I've heard of people who are in the midst of divorce where only one party signed, and the angry soon-to-be ex comes and ripping signs out of the lawn and threatening to sue everybody who put that sign there, who was involved. You don't want to be on the other side of that. So just do your due diligence. Yeah.
I was reading something one time where someone was saying that there's something that you could talk to the title company about, like a preliminary search, but it's not like a full search to.
Yeah.
What is that?
So there's different kinds of searches. The cheapest and quickest is called a current owner search. And so, you know, these are things that we often pay other people to do at Pike Title. We do have our own abstractors on staff who will do them. The reason that we don't often do current owner searches is because we're going to do something called a full search later on in the process. And we don't want to double charge anybody. But if there's concern at the beginning, or if they just genuinely don't know, if you approach somebody, they're like, yeah, you know, my grandfather died and left it to my dad, and then we got it, and we don't know who's. You could ask or advise that client to purchase this current owner search, which would at least tell them if there are issues with who owns what. It's not going to solve those issues. Sometimes you get a current owner search and it shows that there's all these other people that we don't know about. You know, we need to get a family tree to figure out who the actual heirs are who own things. But at least you'll find out, for example, that person doesn't have full ownership of it. So current owner search is what that's called, I think.
And about what do those run, ballpark?
$25 to $50. Yeah,
Okay,
they're pretty cheap. It doesn't take long for our abstractors to do that. It can get a bit more expensive if it's in a rural county, because that means somebody's going to have to visit that county. It can also be more expensive if, for example, the current owner is not, you can't discover it by just looking at a deed. Maybe you have to go way back and do a family tree to figure out who the current owner is. But at least in that case, you get an answer that we don't know who the owner is. And that's enough to kind of tip off your potential seller that they need to do some work and try to pay some more money.
So if someone tells me they're the attorney, does
Yeah.
that mean they can sell the property?
It depends. Yeah, it depends. Yep. So the attorney, in fact, is somebody who's been granted a power of attorney. That's usually been done by somebody while they're living. When they pass away, the power of attorney dissolves. And so you can't be an attorney, in fact, of somebody who's dead. It has to be somebody who's living. Now, whether that person can transfer property that's owned by the person who gave them that power,
really depends on the document. And so, for example, in a lot of estate planning situations where an attorney is drafting a will and a living will, they're also going to include something called a durable power of attorney. And a durable power of attorney is a document that takes effect. Well, there's something called a springing durable power of attorney.
Okay, that first.
You don't have to get
Yeah, I
that.
won't get into the nitty gritty, but bottom line is, it depends on the document. Yeah.
Well, I would take, if it were me, I would take a picture of the document and I'd be sending it to you and being like,
Yeah.
hey, can this person convey this property?
Sure, yeah, I mean, you can skim through it and sometimes it'll be in really plain English that, you know, this person has the ability to sell real estate, but if there's a question, yeah, you can send it to me, I'll take a look at it for you. Those documents, by the way, have to be recorded with the deed, and so we're gonna need the original of it if the attorney in fact is going to be the one selling. We need to, when we write that deed, it's gonna be from, so let's say, Barbara Smith is the owner, but her daughter, Susan Smith, is gonna be the one selling the property because she's the attorney. In fact, we're gonna have to get, the deed is gonna be from Barbara Smith to the new owner, but Susan Smith's gonna sign, and we're gonna attach that, that power of attorney to the deed with it, so that when people look at the land records, they know why Susan Smith signed instead of Barbara Smith, if that makes sense. All right, let's move on to number 9. Misleading clients, whether intentionally or not, can get you into some trouble. And so, you know, in Virginia, most obligations of a real estate agent are in statutes. So the big law to pay attention to is VA Code 54.1-2131, or 2132. So the 2131 are the obligations of a listing realtor, and 32 are the obligations of a selling realtor. And those obligations are kind of laid out, but among those is the duty of honesty. The duty that you have when working with your client or others, whether that's other agents or other people, you have a duty to be honest. And so what that means can vary depending on the situation that you're in. So one of the situations that I've seen quite a bit is, and so I'll be frank, most of these are unintentional. It's pretty rare to see an intentional misleading from a real estate professional. I think most of us don't wake up in the morning intending to tell somebody a thing, right? Even if it means lining our pockets. I think most people are upstanding and honest enough to avoid those situations. But I see quite a few situations where there are unintentional mistakes that are made. And those misleading statements can be just as damaging as an intentionally misleading statement. And by the way, it can also incur liability for you as the real estate agent if it was done negligently. So we get back to that ordinary care statement. And so here's some situations that I've seen some unintentional mistakes that are made that have misled clients, either your own clients or the clients of someone else. Land use restrictions. So these are situations where, you know, maybe it's an HOA, maybe it's a neighborhood. It's usually a planned development of some kind. So when you're driving through a neighborhood and there's all these houses that look similar and they're all planned close together, you could probably assume that there is a document that lists certain restrictions, things that can and can't be done on those properties. Those might include building a fence. Those might include having chickens. Those might include, you know, how many dogs you can have. I mean, there's all kinds of things. Really, the only things you can't limit are things that have to do with civil rights, like you can't say who, you know, what kind of race of people can live in your neighborhood, or protected classes in general. But there's a lot of restrictions out there. Some are kind of crazy. There's even, and I don't know that there are around here, but especially in Northern Virginia, there are planned communities that don't allow you to rent your property. And so if you're planning on buying it and then moving in a couple of years and renting it, you know, that's something that's really important to know. And so what I've seen is situations where particularly a selling real estate agent will advise the buyers on what they think the restrictions might allow and what they think the restrictions might not allow. And specifically, I had a situation where somebody said they knew that this buyer, for whatever reason, was adamant that they were going to raise chickens. They wanted chickens. This house had to be able to allow them to raise chickens. And so that, you know, that in that particular situation, if you're the selling realtor,
you better not speak out of turn about whether chickens are allowed in that particular place. And if you do, and your buyer relies on that statement, you could be liable if it turns out that they can't actually raise chickens. And that was a major reason that they decided to make that purchase. So land use and restrictions, you don't necessarily have to know what they are, but what you should always say is you don't know rather than guessing if you don't know what they are. And the safest thing to do is ask for a copy of them if you can. So,
But if you can't get them from the client, you can go to you as long as they're willing to spend the money.
Right.
Go ahead and get it now.
these are the land records. That's right.
You'll go to the courthouse and.
Absolutely. Yep.
Land use is the same as deed restriction, right? Or-
Yeah, so land, it depends. Yeah, so those aren't technically legal terms, but land use could be also determined by zoning ordinances, for example, like whether you can build multifamily or single family. They could be determined by whether it's a floodplain or a flood location or not. There's all kinds of things that might restrict what you can do. But I think the most common ones that we run into and where the most issues come from are deed restrictions or development restrictions. Sometimes you'll find them in the original declaration that the developer files in the land records at the beginning of creating a subdivision or land development. But
And then I also find with realtors, they're like, oh, well, the neighbor has chickens, therefore
Right.
chickens are allowed. And
Yeah.
I'm like, no, the neighbor has chickens and they may or may not be allowed.
correct.
The neighbor has a fence, they might have done it before the restriction, I don't know, but I'm not gonna tell them because the neighbor has a fence.
Yeah, no, that's a really good
Yeah.
point. Yep,
Yeah.
because restrictions are violated all the time. And just because they're violated doesn't mean that your buyers are gonna be able to violate them too. It's, sometimes that if everybody's violating the restrictions, sometimes that does mean that your buyer might be able to as well, but that's legal. And that's
That's a
complicated
them.
and it's not something you should be advising on. It's not something that I would even advise on without doing a lot of due diligence and a lot of digging. And so, yes, regardless of whether other people in the neighborhood are doing it, it's dangerous to tell your client that they can do it too. And then there's also kind of weirdness with restrictions where some lots may be grandfathered in because they were already there when the development was created. Or there's some weird line between this part of the development and that part of the development. It's not clear when you're looking at it, but when you look at the land records, there's different restrictions that apply to each. So, yeah, be careful and we can look that up.
So, I mean, we are a buyer beware state. And so while the listing agent doesn't want to go on record saying, yes, you can have the fence, yes, you can have chickens. Wouldn't it still fall on the buyer and the buyer's agent to get all of that information and investigate them those on their own?
Absolutely, yep. And so I want to be very clear that this mistake is realtors pretending they know something that they don't. But it is 100% okay, and probably in most situations like this, best practice to say, I don't know, but
Check it out.
yeah, check it out, do your research. I'll send an email to the listing agent and ask them about it, or whatever the case may be. But yeah, this is just about making statements that are misleading. So be careful with that. It's buyer beware. You're right.
And you ask the listing agent, get it in writing and copy and paste.
Yeah. Yeah, and by the way, and just to kind of add one more thing to the buyer beware piece, in most contracts, Lynchburg Association of Realtor contracts, there's an obligation that the seller disclose these documents to the buyer. But here's the thing, if it doesn't get disclosed and closing has taken place, too bad, so sad. Seller's out of luck, or buyer's out of luck. Your remedies as a buyer are only available to you pre-closing. After closing takes place, if that's the first time you realize that you didn't get those necessary documents from the seller, then you're stuck with whatever those documents may say. So be careful with that too. But also realtors pay attention to the deadlines because sellers are required to disclose these things. And if they don't, it's probably best for you to follow up and make sure that they do. That pretty much covers the main pieces of this. Any other questions on kind of misleading statements with land records? Same thing applies to the condition of the property. You got to be careful about advising others on whether the property is, what the shape of it is. Because at the end of the day, it's again, buyer beware, but you don't want to step in something that you're not fully prepared to discuss. And so that's often it gets involved in in situations where there have been significant renovations that the seller's done. Sometimes those renovations are done well, sometimes they're not done well, but if there's questions about defects in a property, unless you truly know the answer, it's probably best to defer and advise that they get an inspection, maybe even advise that they hire a specialist to look at a roof or an HVAC system or the foundation. But assuming that things are fine and then presenting that confidence to a client can be dangerous if things turn out that they aren't fine. Number 7, failing to keep client data safe. In a world where most sensitive data is transmitted electronically, it's an obligation of all of us to keep that data safe. And that includes real estate agents when they're handling data of their clients. And oftentimes that's done when you're transmitting documents to and from the various parties, because a lot of sensitive financial data can be put into those documents. I know from the settlement company side, what we do at Pike Title, it's very, very important, because not only are we transmitting documents and information, but we're also holding money and sending that to various places. And so wire fraud is definitely a major issue for us. But there's lots of ways that these sophisticated fraudsters are able to get into emails, systems, and maybe the ultimate target is the settlement company, but if they do it through you and you're, maybe they hack your computer or they send a phishing email that you click on, and then now they're sending emails from your account to the settlement agent, sending or requesting false information. Depending on how it happens, there could be liability that's created in those situations as well. And so the best practices are always to verify the authenticity of information before you send it. So that can be done in a phone call, that can be done through using secure portals. Particularly if you're working closely with a lender and the lender's sending you some of this information, you got to be careful to safeguard that. Some of the most sensitive pieces of information obviously are the social security number, but that also includes birth dates and bank account information. And that's information that's often going back and forth over email during the transaction. And so there's no perfect way that you're going to be able to safeguard every client every time, but there are standards that you could be considered negligent if you don't meet. And some of those standards probably include carefully looking at emails that you get, especially if they're requesting sensitive data, before you reply to them with that sensitive data. They probably include if money is being transferred, for example, if you're holding an EMD of some kind.
You don't do that.
Yeah, you don't do that.
We don't do that.
All right,
I'll never
good.
do that, yeah.
Because there's all kinds of complications if you have money involved, but just best practices, be vigilant, be aware. Phishing and wire fraud are big problems. I mean,
I have a client that tries to send it to me, I'm like, no, you send it directly to the title or the lender, and never the middleman.
Yeah.
That's just, I'm like, nope, I just don't.
that's best practice.
And the one that I have gotten from people is proof of funds, if you have a cash deal. I've gotten one that's like, yeah, I got 750 and here's the account number, their name, I'm like, oh.
Yeah.
I'm gonna take a picture of it. I know, I was just making sure I deleted the pictures of people on out of my
I'm
phone.
like, never do that, so black it out. if
I
you
do, I have to get it, but and
Black it
DocuSign
out.
will allow you.
And
to
then I'm
black
like,
out all
but
that
it was
information.
another agent, not from this firm, sent it to me,
And this should never be sent via email, but account numbers, never.
Right.
well, this was by text even, but
I
I'm
know,
like,
I'm
well, I
worried
don't
about
trust
trust.
it.
Yeah,
Yeah, there's a lot of ways for it to be taken by somebody who's going to use it for identity theft or wire fraud or who knows
Proof
what
of
else.
funds is the one.
yeah.
Yeah,
We're still in.
that's a good example. So be vigilant. We get dozens, if not hundreds of phishing emails every week. And so, yeah, we're constantly looking on the lookout for those sorts of things, but I know that real estate transactions in general are considered soft targets among these folks who are trying to scam people, because typically it's done by smaller organizations or individuals who don't have these big fancy IT departments that are blocking. And it's also done mostly electronically among people who sometimes don't even meet each other. And so it's ripe for fraud, so be careful.
There we go. Giving legal advice. This is one that I see fairly often. Thankfully, it's not one that I see litigation come out of very much, but it is something to be aware of. Because as a real estate agent, your clients really do rely on you for a lot of things. And a client probably doesn't know the distinction of legal advice versus just good advice from the real estate agent. And so you, as the real estate agent, really have to be the one to inform your client what that scope is and where you're crossing lines. And if something really is a legal question that your client has, when to refer that out, or to at least tell them that that's not something that you're able to advise them on. And so these sorts of things come up pretty often when it comes to interpreting contracts, because, interestingly enough, one of the obligations that are listed in that statute 54.1-39.4 is the obligation to negotiate contracts and negotiate addendums and negotiate counteroffers and offers on behalf of your client. And so where is the line crossed between negotiating those things and getting legal advice? It's not going to be black and white, and it's really going to depend on the situation. Certainly, you're allowed to write additional terms in that section at the end of the contract. Certainly, you're allowed to try to use the templates that you're given to the best of your ability to represent your client's interests. But there's probably situations that you're going to have to ask for legal advice on behalf of your client, or your client's going to have to ask for advice before you get a contract signed. If it's particularly complicated, it's probably there's probably a line that's going to be crossed at some point if you're going to try to draft in the additional term section, for example, whether an easement or where an easement's going to be, or how an easement's going to be created. Those are things that can be complicated and are the practice of law. And so maybe something that you prefer to an attorney before advising your client. That also includes drafting legal documents. So you have those templates, the Virginia Association of Realtors, Lynchburg Association of Realtors, whichever association documents that you're using, gives those documents that have been drafted by attorneys and are meant to be customizable so that you can check boxes and fill in blanks without drafting those documents. But you shouldn't be kind of going off on a limb. What I've seen sometimes that probably crosses the line, thankfully I haven't seen litigation out of it, is when the buyer is negotiating pre-closing occupancy. When the buyer is going to move into the house before they actually purchase the house. Because unfortunately, the form that you're given is usually like a one-pager. And when it comes to, which is strange in my mind, because if you look at a lease agreement, typically those are 5 or 10 pages. And so what I see many times is when realtors are trying to negotiate what the terms are of that pre-occupancy, they're trying to squeeze a lot of legal terminology into like, what kind of notice needs to be given, or what happens in the event that rent isn't paid on time, or what the late fees are, or what the number of occupants must be. I mean, there's all these terms that would normally be in a lease agreement that really don't fit on the lines when you try to squeeze it into this pre-occupancy form. And so a lot of those situations probably lend themselves, if it's going to be, especially if it's going to be a long one, it's going to be more than maybe 30 days. It's probably best to have a separate document drafted up on behalf of your clients that really lay those terms out. And the consequences of trying to do it yourself, thankfully, don't often end in litigation. Because usually if somebody practices law without our authorization, there's bigger problems out there, and it's usually that somebody's lost a lot of money or they haven't, so they're going to be suing you under those kinds of theories. Not that you practice law unauthorized, but that you drafted a lease that left them with a house they couldn't sell and a squatter who won't leave. Those are the kinds of things that you get yourself into. But know the distinction if you can, and if you're not sure, always ask. You want to try to avoid those situations.
What I have done in some of those situations, and additional terms, and I think of owner financing, is I say, 10-year note, 5% interest rate, that you're gonna draft it and it's gonna be okay by both parties within X amount of days.
That's good, yeah.
So if you do whatever that is, that he's given a timeline on how long the lawyer has to draft it and that both parties have to approve it.
Mhm.
And then,
Yeah.
and then we
That's
have something that can just be recorded and we're not waiting till the end to figure it all out.
Right, yeah, and so in a situation, for example, where there is pre-occupancy, you can put something in the additional terms that buyer and seller will agree to a lease within 12 days of contract signing. The consequences, if they don't agree to that lease, you could probably put the consequences, what the consequences might be, because otherwise you may get into the situation of one party deciding to pull out of the contract, and that wasn't the intent to go in with, but yeah, you can always refer to potentially drafting other documents, and that's advisable. There we go. Missing deadlines in a contract. All right, this is kind of a big one because there's a lot of deadlines in a contract. And actually, one of the things that you're responsible for as a real estate agent is making sure that your clients meet their contractual obligations. And so when you are, when you're in that contract phase, buyer and seller have signed, you're doing your due diligence, you're going through the inspection process or appraisal process or financing process. It's important to keep these deadlines in mind and make sure that you're on top of them. And if you got a lot of contracts out there, it's easy to let these things slip through the cracks, and the consequences can be pretty devastating depending on the deadline that you're missing. And so EMD deadlines are some of the most stringent, because if you don't pay the EMD where it's supposed to go, when it's supposed to go there, a seller is typically allowed to pull out of the contract. And it's actually one of the few deadlines that if it's missed, voids the contract on the day that the deadline expires. Others have a little bit of wiggle room, or the consequences might not be so drastic, but EMD is a big one. And so often you can fill in the blank for how long the buyer has to pay that EMD, but you're usually going to say where the EMD must go and how much it must be. And it's typically incumbent on you as the realtor to help your client understand that obligation and to make sure, to the extent that you're not overriding what the buyer wants to do, that obligation is met. And so,
And Aaron, if we use Pike Title, can you send us an email?
Yeah.
yes, I do.
So I would say use a title company that
Yeah,
sends us that, and I think your FOIA Act also.
it absolutely does. And actually, I've got a slide right after this specifically for EMDs, because there's other concerns about EMDs, but you're right. Our Quality app, starting Monday, will allow your clients to take a picture of a check and submit it to us. And so that creates,
So they don't have to drop it off?
they don't have to drop it off.
Oh.
It's just like most
I
people
knew it was
probably
kind
use
of end of
an online
October.
banking app where you can upload checks just by taking pictures of it.
Yeah.
Same concept. It'll be through Qualia Connect. Your buyer will click on the link in an email that they're going to get, or just create an account online, and that will walk them through the steps of taking a picture of a check and uploading it, and it'll automatically notify us and automatically send a receipt to them, and we will be able to send a receipt to all the other parties who need to know that we got that EMD. So
Does it have to be a check, or can it just be an ACA?
right now it has to be a check, and so there is another feature that is not fully live, that eventually a buyer may be able to link their bank account and transfer it electronically, but right now it has to be a check. There's also an app called Earnest, and I know that we're connected with Earnest. Earnest is something that I think Keller Williams is already subscribed to, and that's another electronic app where your buyer can submit the EMD. But I think the buyer pays a fee to do that through Earnest. To connect, it's free, and it also notifies us automatically if you do the app that we use. So yeah, I would definitely suggest using that. EMD deadlines are a big one. Inspection deadlines, that's another big one. So when it comes to real estate inspections, under very few circumstances should you be advising your clients to waive these. And so most of your transactions will probably involve an inspection or two or more based on the property that's being sold. And there are almost always deadlines for when these have to take place. If they don't take place during those deadlines, usually the buyer waives their right to have those inspections. And so you've got to be careful about scheduling these things, or at the very least, making sure that you give your buyer sufficient time when you're filling in the blank for how long they have to do these inspections. You know, if it's a fund, for example, or let's say it's unimproved again, they're planning on building a house on that lot and they want 4 bedrooms. One thing that you typically have to do is you have to make sure that they're going to be able to install a septic system on that land. And so that includes a perk test, which is an additional test that your clients are going to have to do. You know, those are things that you got to think through and make sure that there's enough time in your contract for those things to take place. Because if you don't do them in the deadline, you may not get a chance to do them at all. And at the end of that, if your client ends up purchasing a property that they can't use, or a property that's different than what they thought they were getting because they missed that deadline, they're going to be looking for people to blame, and it might be that you fall into their crosshairs, and you don't want to have to defend yourself if you miss the deadline there.
Are those days calendar days?
These are all calendar days. Yep. And so that's a good point too. Yeah.
Sometimes people ask.
Yeah, I mean, I can't think off the top of my head of deadlines that are business days, but yeah, and so, and if there ever is one, it's gonna be very explicit that they're business days, not calendar days, but.
Clothing disclosures.
Okay, closing disclosures are, that's
For
right,
our
business days, yeah, for lenders, that's a good point, yep, so deadlines for lenders and title companies, you have to get it to the client 3 days, 3 business days before closing. But these contract deadlines are almost always, and I think even they are always, I should even say almost based on calendar days. And so make sure that if you sign a contract on a Friday, you're aware that you've already lost 2 days by the time you come back to work on Monday. Financing, that's another big deadline. So, you know, most of the time, in our industry, that this listing agent or the seller is going to require proof of funds or pre-approval letter of some kind before agreeing to sign a contract. But as lenders know, and as most people who've been in this business know, there's a process after the pre-approval before there's an actual commitment to lend. And that process is when actual financial statements are dived into and real information is looked at. And sometimes somebody may get a pre-approval but fail to get a loan commitment for whatever reason. And typically there are deadlines for when somebody needs to apply to a lender that haven't done so already, but there's also deadlines for when they need to have a loan commitment. And so those things are important, and especially on the seller side, you know, you may not want to wait if you've got a listing that you know a lot of people are interested in, but you've accepted an offer from a buyer and now there's complications with their financing. Maybe they had that pre-approval letter to begin with, but now we're in the middle of things and all these issues have popped up. I'm not sure if they're going to get financing. Knowing those deadlines may be beneficial to your seller client, because that may give you the authority to back out of a contract at a certain point rather than just holding it in limbo month after month after month. So pay attention to those deadlines as well.
And if you're on the listing side, so my first deal, the selling agent has been in the business 20+ years. Her clients had a solid pre-approval letter, and sometime in the process, they called the lender and said they were just going to get a cash deal, but they never told anybody else. And so it's helpful to just make, you know, keep in touch with the lender about that if your buying agent is not giving you those updates.
Yeah.
Because we let them get early possession and they indeed were squatters, and it took us like 6 months to get out of the house.
Yeah, early possession is always deadly. It's fraud, so you got to be careful. Once somebody's in the house, there's so many laws that protect them from being evicted, and you got to be careful. But yeah, for sure, those financing deadlines are important, regardless of whether that's pre-approval of it or not. There's all kinds of things.
I didn't know what I didn't know.
That's why we're here, right? So we can avoid some of those problems.
For folks that are holding EMDs, I'm a listing agent, EMD, is being held by the buyer's agent, not a title company.
Mhm.
So I've asked for verification of the EMD, like a check, show me the copy, and I haven't received it, and he says he's got it.
Mhm.
Right.
Yeah.
I mean, because I keep going back to, they have to be honest, I wanna trust that they're honest and all of that, but at the same time, you're the one holding the EMD.
Yeah, I mean, it's definitely best practice to take a copy of the check and send it to people.
Right,
But if they don't, I don't think that that's grounds for termination under that E and D paragraph in the LAR contract. Yeah, but I can understand why it would make you nervous. Ultimately, if the EMD wasn't given to that realtor or they didn't deposit it and it turns out that it wasn't a good check, there's gonna be a lot of liability on that side and a lot.
they're obligated to deposit it, right? So if the client, I asked him if he's received, they turned in their EMD. If EMD deposit, would they, the ethics are, if you're holding EMD, you have to deposit it,
I
right?
think the broker rules.
Yeah,
Guide that.
yeah.
That's a whole different stuff.
yeah, broker rules, there's a lot of broker rules and D4 rules and ethical rules, and he would violate all kinds of them if he hadn't deposited it yet and told you that he just didn't receive it.
Yeah, I got it.
Yeah. But yeah, I think best practice is to check, and that's what we do. All right, so negotiation period, that's another big one. So negotiation period in a contract is that time when the inspections have been done and maybe there's some repairs or improvements or things that the buyer wants. So they're gonna negotiate whether things will be done or they won't. The deadlines in this negotiation period vary between contracts. They're gonna be different in the LAR contract than they are in the RVAR. So, Roanoke Valley Association of Realtors, which are different than, VAR, Virginia Association of Realtors. And so paying attention to the deadlines in the contract that you're being given, or that you're giving, is incredibly important. In the LAR contract, there's a 7-day negotiation period, and that's the period under which there's offers and counter offers flying back and forth, but neither party can cancel the contract during that period of time. And so buyers may ask for the moon and the seller may say, no, we're not going to do any of that. If it's within that 7-day period, you're still negotiating. Contract hasn't been terminated. The most important thing though is after that 7 days has expired, if buyer and seller haven't come to an agreement, what deadlines do you have to pay attention to? And there's some really important ones here because these are the big differences between the contracts, and that's whether the contract's canceled or not. So if you don't come to an agreement, typically that means that your buyer doesn't want to buy the house because they're not agreeing to what the seller's offering to do. And so they're probably ready to walk away. So under the LAR contract, you have 2 days to cancel. It has to be in writing. But here's the thing, if you just don't respond, the LAR contract terminates automatically. And so that's usually the outcome that the buyer wants. And so the LAR contract is buyer friendly in that respect, because if you forget, you miss an email, if it's the weekend and 2 days go by, and you send an email canceling the contract on the 3rd day, and you miss that deadline, the contract's canceled by default. And so that's something to pay attention to. But RVAR and VAR contracts don't cancel by default. You don't cancel within a cancellation period, they are automatically ratified. And so you can really get your client, especially if you're representing the buyer, into some trouble because they didn't want to buy the house. That's why they didn't agree during the negotiation period to the repairs. And so if you miss that 2-day deadline at the end of the negotiation period to transmit in writing to the other side, the intent to cancel, chances are you're going to be stuck with that house. Your buyer's going to be stuck with that house. And you as a realtor are exposed to a lot of liability as a buyer realtor, because ultimately you're probably the one that's sending emails back and forth on behalf of your clients. And so those clients are reasonably relying on you to send and receive those emails time, those deadlines. So the negotiation period deadlines are incredibly important because it's almost always done between realtors. It's not done between clients, and it can really be the difference between whether your client's buying a house that they want or whether they're being forced to buy a house that they didn't want. So pay attention to that.
All right,
So special slide for failing to ensure the E&D is deposited on time. I kind of discussed the deadline with you. And why that deadline is important is typically if you don't send it by the deadline, that gives the seller the right to back out of the contract without anything more. But you also have to pay attention to where it goes. So whether it's being held by a particular agent or a particular broker, or by the title company. As Tina said, best practice, why not send it to the title company? Pike Title's happy to hold it. Most title companies will hold it for you. And there's liability attached to it. And so I never understand why brokers prefer to hold it themselves. In my mind, it just creates obligation for them that they don't need. So best practice, get your buyer to take the money directly to the title company and deposit it with them. Do it through our app, have them deliver it in person. It's always dangerous if you agree to do it yourself. And so I would advise against accepting a check or agreeing to drop off a check on their behalf. Calendar days, we already mentioned that, rather than business days when it comes to the deadlines, but EMDs are that first deadline typically in a contract are the ones to pay attention to the most, and they're the most consequential of this.
all right, number 3, failing to communicate offers and counter offers. So these are situations that we often run into, or that I see when there's either an offer on the table and a new one comes in that's not transmitted, or we're in a negotiation period and somebody misinterprets that for a counter offer that voids the contract. And so both of those situations, I'll kind of explain to you in a little bit more detail, but under the first situation, so I guess kind of basic offer, counter offer law for you. An offer is considered an offer when it's transmitted to the person who's supposed to receive that offer. And so that usually means once you as the selling agent have drawn up that contract and pushed send on your email. It's not when it's received, it's when it's sent. That's when an offer is sent. A counter offer is anything that modifies that and asks for changes on the other side. And so you send that offer, but there's some line throughs and changes to it. And then the listing agent sends that back to the selling agent. That's a counter offer. The effect of a counter offer under normal circumstances is it removes the buyer's obligation to purchase. So typically, if a buyer sends an offer and the seller says, I accept, that's the end of it. The contract is formed. But if a buyer sends an offer and the seller sends a counter offer, kind of resets that whole process. The buyer is not required to accept the counter offer. The buyer is not required to accept their original offer. So if there's a counter offer, it's going to say, oh, no, wait, I changed my mind. I'll take that initial offer that you made. So the buyer is not going to be required to accept that under normal circumstances. So counter offers are significant. The difference, though, when you get into the negotiation period, is that those same kinds of communications do not have the effect of voiding an offer or restarting or voiding the contract. You're required to, for at least that 7-day negotiation period, continue to go back and forth. And so there's been several situations that I've seen where clients have gotten into that negotiation period. The buyers have asked for a super long list of repairs. The sellers have refused to make those repairs on day 2, and then it just kind of languishes and there's no further communication after that. Under the LAR contract, kind of like we discussed, that's going to, if you don't respond and nobody pays attention to it after that, it's going to cancel the contract, which might be what you wanted to do. But you got to be really, really careful under RBAR and VAR contracts, because there's got to be a follow-up communication. That counter offer that would have normally voided the contract under period that wasn't the negotiation period didn't have that same effect during the negotiation period. There's still a requirement that a written notice of cancellation be sent under the RBAR and VAR contracts. And if you're doing business around the lake, for example, you're probably going to get some RBAR contracts
But we've seen VAR contracts come through our office too, and so it kind of depends who you're dealing with on the other side. I think Keller Williams, LA. You gotta pay attention to those little differences there.
In this negotiation we're talking about here, and the mistake here is not forwarding, so we're talking about the contract negotiation in the inspection period, right? So there's a negotiation, and I just ran into this, so get the repairs request, I'm the listing agent. We say, here's our counter for that, you know, here's what we're willing to do, we want an answer for this, and then no communication from the buyer's agent for 48 hours. And I'm calling and I'm emailing because they gotta know, because they're expensive things, and if we're gonna do them, we need to schedule and all of this, stall. There's nothing that can prevent, you know, we're just stuck at
Yeah.
that point until the other person decides to respond.
Yeah.
And then get it in writing. But this says not, what if he admits he hasn't forwarded to his client because he's on the golf course?
Yeah,
So, you
Big
know, at
problem,
what
yeah.
point, yeah, you know, because he's like, and he said that, I didn't talk to my clients. I'm gonna talk to him after work on Monday, it's turned into Tuesday. So, you know, there's nothing we can do, right? We're just stuck.
yeah, I mean, so your obligation is to communicate timely, but if they're not going to respond timely, that is on them, and so. The situations that I've seen that almost that identical situation come up is. Typically over a long holiday weekend. There was just no negotiation between buyer and seller, agents. And then the deadline expires on Monday, and then that's when the selling agent says, oh, we accept everything. Or, you know, here's some line throughs that will fix these and not that. And there's an expectation, because maybe they didn't even realize the deadline had expired, that there would still be communication after that point. But there's no obligation to respond, and there's no obligation to extend that deadline once that's.
Or tell you you're not gonna respond.
Yeah, or tell you, yeah, yep, so, the deadlines
It
are
seems like
incredibly
a flaw,
important.
yeah, it seems like a real flaw in
Yeah,
sellers, and that, my thought was, if that happened and this person did, I'm keeping their EMD, there's no way we are not, you know, we're signing over that EMD to get that back if they get that.
so it really depends. I don't think I would have drafted the negotiation period language the same way that the LAR champions did, because it does create weird situations, yes. I mean, even though you have to be on top of things more under the other versions of the contract, because they ratify rather than cancel. I think that's better for both sides, because it forces that communication throughout the negotiation period.
If you get somebody uncooperative on the other side,
Yeah.
it's just stuck.
So, yeah, no obligation under the LAR contract, no obligation under any contract to respond, but under RVAR and VAR, if you don't respond, you're gonna go to closing. And the terms of that closing typically don't require the seller to make any repairs if you didn't agree to anything.
So there's more motivation for
Yeah.
buyers to get it together.
Yeah, exactly. There's motivations for both parties to decide what they really want to do.
That's interesting. So in VAR and RVAR,
Mhm.
if there's no agreement, then seller obligated. It does ratify, but they're not obligated
Correct,
if they haven't come to an agreement.
correct, yeah,
Interesting.
yeah, so great for sellers if there's just a lack of communication, very important for buyers and communicate that cancellation.
Good to know.
All right, making suggestions beyond your expertise.
This happens often in the context of repairs, renovations, because it's fairly common, I think, for buyers to walk to the house and talk about the things they want to change, the condition of the house or the condition of recent improvements. And it's fairly common for people in the course of a regular conversation to comment on those things, like, oh, roof looks like it's, you know, it's brand new, or it's leaking, or, you know, this basement's got cracks everywhere. I think we got some serious foundation issues. Be careful about the advice that you give if it's not your area of expertise. And when it comes to renovations in particular, obviously you need to disclose. And so the duty to disclose is triggered by anything that you as an agent have actual knowledge. So if you have actual knowledge of a defect that affects the property, you're required to disclose that to not only, potential buyers and sellers, but, well, I mean, those are the big parties that you would. It's, if you present your expertise, as a contractor and start to talk about how certain repairs have been made that have resolved issues in the past. You know, maybe, for example, your seller tells you about foundation issues that they've repaired. If you then go out to potential prospective buyers and say, yeah, there were foundation issues, but I'm confident they're fine. You know, my seller took care of them. He's a qualified contractor and he fixed everything. You now put yourself in the shoes of an expert advising another person. And so if that advice happens to be false, whether it was intentional or not, you would be on the hook if there's potential problems. And so be careful about what you make statements about. It's much better to refer your clients to the appropriate expert, whether that happens to be an inspector or somebody else, rather than making those statements yourself. Land use and restrictions. So that's we kind of discussed that already, so I'm not going to go through it again in detail, but don't advise on what they can do with the property unless you're 100% sure what they can and can't do on that. The law.
I usually just try to be helpful. Here's the Bedford County, zoning person. Here's the website. for
Yep.
Bedford County. And I'm like, I'm not gonna interpret it.
Yeah, no, that's the best way to go about things. Situation that I had where a realtor ran into trouble, this particular mistake was that their client seller was a flipper. He bought a house that was in terrible condition, really made it look beautiful, but just put lipstick on it. And so the roof still leaks, the foundation issues were still there, they were just covered up with drywall. And the problem was that a particular realtor had toured the house before the renovations. And so they knew about all of this. But they made the unfortunate assumption that their client had fixed them all and they were no longer issues. But that was a false assumption. And you know, it's a complicated legal issue. This was resolved before their court was brought into things. I'm not exactly sure how a judge would rule on that situation. But there was definitely potential liability on the part of the listing agent for not disclosing these defects that he knew existed before the repairs, even though he thought those repairs would resolve those issues. And so best just to be upfront, honest, over disclose those kinds of things.
So Aaron, on the residential property disclosure, really, there's no place to. Would that just be a write-in essentially for on the agent side, or how?
Or an
would-
email. Yeah.
Or just in an email? Okay.
And actually, so we'll just go to my number one, because these kind of blend in a little bit, making suggestions
Okay.
beyond your expertise, but failing to disclose a property defect is the number one mistake that I see realtors make. And so here's what the duty comes down to. You've got the statute that's 55.1 dash 3841. Sorry, 2130. That outlines the duty of honesty and the duty to disclose actual defects that you have actual knowledge of when they are regarding the physical condition of a property. And so that means, for example, that any kind of structural defects, any kind of defects in the roof or the foundation that you know about, that you have actual knowledge of, have to be disclosed. It also means that if you go into a basement and you see giant foundation cracks, but your seller tells you, oh no, don't worry about those. You can't be willfully ignorant. And if you know that it's a problem, or you should know that it's a problem, it trumps your ability to rely on the advice of your seller. So under normal circumstances, realtors are protected if they rely on the information that their seller gives them, or they rely on the information that an expert like an appraiser or an inspector gives them. You can rely on that information even if it's false. If you transmit it to somebody else,
and it's false, it's not on you, it's on that person who gave you the information. That doesn't apply when it's clearly, when you're given clearly false information, because you're allowed to reasonably rely, but you're not allowed to be blind, willfully blind. And the difference in whether it's reasonable or not probably depends on how egregious and how visible that defect is, how much you know about it, how much you know about the history, and what kind of questions that you ask. And so be careful with a shady seller who may know that they put drywall to cover up a foundation crack, or done some other, electrical work that isn't up to code and maybe a fire hazard and they weren't qualified to do it. If they tell you everything's fine, you may still need to ask additional questions to completely protect yourself from potential liability. And it's going to be situation dependent. One of the things that you don't have to disclose are things that don't affect the physical condition of the property. And so those may be, and a lot of people may want to know these kinds of things, but you don't necessarily have to disclose them. And those are things like whether somebody died in the house. If it doesn't affect the physical condition, you don't have to disclose a homicide. You don't have to disclose suicide. You don't have to disclose any felony that was committed in the house. There's a specific statute in Virginia that said realtors are not obligated to disclose those sorts of facts. And so, you use your best judgment whether or not to disclose that or not, but it really has to relate to the physical condition of the property. It can't just be these kind of psychological things that people might feel uncomfortable with, but don't actually affect the house. So the remedy, what I advise everyone, over disclose. If you're unsure, it's better to tell people what the issue that you perceive is, and then ask those obvious questions of the seller. If it seems clear that there are issues that should be disclosed, follow up and ask the questions so that you know what the answer is. And with that, all right, 1:15. That's it. Those are the top 10. That's what I came up with. I hope you learned a little bit. I hope you visit us at Pike Title if you haven't done that. But I'm happy to answer any questions that you have based on that presentation.
That was good stuff.
Yeah.
Thanks a lot.
Cool. Thank you, everybody.
Yes, I'm the only primary able to have the sewer system. With floods that are.
Okay.
And so. Did they have legal obligation to continue that?
Maybe, maybe not. So if it's with Georgia Pacific, the private company, then it's probably subject to an easement. There's probably been some document in the land record that outlines the requirements of that sewer system. If there isn't, then it could be dangerous. I mean, if there's not a written easement in the land records, it means that there's no guaranteed right for that property to continue. Sewer system.
Like, not for lot, yeah, like. I would
Yeah,
use-
so potentially a separate
This one.
document.
Okay.
One of the things that are typically we do a search. So, that's a deal breaker, it's a deal breaker, and the client really needs an answer to that before they get into the contract. Because they
And
can't paying
It's even got, it's on the
can be
Lee
to a couple
Highway.
$100 to find out the answer. So we can do a full search before.
I know it won't be
closing.
exact,
But
'cause
under
this is
normal
referring to
circumstances, after a
what
contract is
section.
signed, we're gonna do.
So it's not gonna be
Pike
the same
Title is
as
gonna
more
do a full search.
like that.
We're gonna find
1.6
land
acres.
records. We'll probably uncover.
I had to
the
clean,
right issues.
I had to clean this driveway.
5.
I would guess it's probably.
Just we,
Georgia Pacific.
there's no cars going on. This,
I would guess there's probably specific.
Keats Auto Care or something.
Oh, it is.
But he also was. That's got tenants. And so what he, the main.
Pacific's not yet?
that owns-
And then I'm.
I guess it's the son of the guy who bought. They just been talking to him. I think, you know, it's probably not- he had to see his driveway. So we got a story all the way to business. But anyway, I cleaned it, and I just have to say, well, that's a nice property.
Maybe.
Right
So
on,
2550 is current.
Lee Highway.
We're trying to find
like
whether
whether
it is.
he's travel that way. And you're coming right down.
What I think he is. That's something.
High traffic. High traffic, yeah.
It's probably gonna be.
The beginning by Lily.
Well, she made it on her document, but it's.